Judgment in the appeal, joint administrators of Heritable Bank plc against the Winding Up Board of Landsbanki Islands.
The dispute which has given rise to this appeal is the product of a failure of Iceland's entire banking system in the autumn of 2008. It is how cross-claims between two credit institutions are to be dealt with in insolvency proceedings in two different states in the European Economic Area. Landsbanki is an Iceland company. Its wholly owned subsidiary, Heritable Bank plc, is a Scottish company. Both companies have been in formal insolvency since 7th October 2008. On that date, the Court of Session appointed joint administrators to Heritable, and the Financial Services Authority of Iceland took control of Landsbanki. The District Court of Reykjavik later appointed a winding up board to Landsbanki. The relevant European legislation is set out in a directive on the reorganisation and winding up of credit institutions, which applies to EU member states and to non-EU countries in the EEA, including Iceland. It was implemented in the United Kingdom by regulations made in 2004. Landsbanki is an EEA credit institution for the purpose of Part 2 of the regulations. Heritable is a UK credit institution for the purposes of Parts 3 and 4. Regulation 5, which is in Part 2 of the regulations, provides in essence that an EEA insolvency measure has effect in the UK in relation to the branches of an EEA credit institution, its property and assets, debts and liabilities, as if it were part of the general law of insolvency of the United Kingdom. The dispute between the parties is about the effect of Regulation 5. Landsbanki submitted a total of 4 claims in Heritable's administration in Scotland, one of which, in respect of a revolving credit facility governed by English law, is the subject of this appeal. Heritable's administrators rejected that claim in November 2009, applying the Scots law rule of set-off known as the balancing of accounts in bankruptcy. This was on the ground that Heritable had claims against Landsbanki, which equalled or exceeded the amount of Landsbanki's claim and which served to extinguish it. Landsbanki appealed against that decision to the Court of Session in Scotland. Heritable then submitted 4 claims in Landsbanki's winding up in Iceland. The Winding Up Board rejected 3 of them and accepted the 4th on a reduced amount. Heritable's administrators formally objected to these decisions in February 2010. Landsbanki argued in its appeal to the Court of Session that its rejection of Heritable's claims was binding on the United Kingdom in terms of Regulation 5, and that Heritable's administrators were bound to hold that Heritable had no claim against Landsbanki which could operate by way of set-off. Heritable argued that Landsbanki's arguments were irrelevant. The Lord Ordinary in the Court of Session found in favour of Landsbanki. Heritable's administrators then withdrew Heritable's claims from Landsbanki's winding up, whereupon Landsbanki issued proceedings in Iceland for a declaration that Heritable's claims had been extinguished. Heritable successfully applied for those proceedings to be discontinued. Back in Scotland, Heritable appealed against the Lord Ordinary's decision, and the inner house of the Court of Session reversed the Lord Ordinary. Landsbanki now appeals to the Supreme Court. The issue is whether the effect of Regulation 5 is that Heritable's claims, extinguished as a matter of Icelandic law, are to be treated as extinguished in Heritable's administration in Scotland, so that Heritable's administration cannot use them to set off Landsbanki's claim. The Supreme Court unanimously dismisses Landsbanki's appeal and affirms the decision of the inner house of the Court of Session. The key to a proper understanding of Regulation 5 lies in an appreciation of the fact that, while it is designed to give effect to the mandatory choice of law of insolvency of the EEA state in which the foreign credit institution is located, it is not concerned with the effects of the mandatory choice of Scots law for the administration of Heritable in Scotland. Those effects are set out in Parts 3 and 4 of the regulations, which have nothing to do with the effects of the mandatory choice of the law of Iceland under Part 2 for the winding up of Landsbanki. Seen in the context of Part 2 of the regulations, there is nothing remarkable about what Regulation 5 sets out. Even if an EEA credit institution has branches in the UK, the entire process of winding up must be conducted in its home state. Applied to this case, this means that Landsbanki's property or assets located in Scotland are not to be disposed of in accordance with Scots law. Steps by a creditor to enforce a claim against Landsbanki must be pursued solely in the proceedings in Iceland, and decisions taken by the Winding Up Board must be given effect in Scotland. In this way, the integrity of the exclusive jurisdiction that is given to Iceland is preserved. But the provisions of Regulation 5 are concerned only with the winding up in Iceland in relation to Landsbanki, and it is only for that purpose that the winding up is to have effect as if it were part of the general law of insolvency in the United Kingdom. The provisions do not apply to the administration of Heritable in Scotland. The rules which apply to the Heritable are set out in Parts 3 and 4 of the regulations. The regulations in Parts 3 and 4 provide that where a UK credit institution, such as Heritable, is being wound up in the United Kingdom, matters such as the conditions under which set-off may be invoked are to be determined in accordance with the general law of insolvency of the United Kingdom. They preserve the right of creditors to demand the set-off of their claims against the claims of the insolvent credit institution, where set-off is permitted by the law applicable to the credit institution's claim. The issues of set-off are therefore to be determined, as the common law of Scotland requires, according to English law as the proper law of the contract. Landsbanki's argument would also produce an arbitrary and unprincipled outcome. Its logic is that Heritable's claims against Landsbanki would have been extinguished even if Heritable had been a wholly solvent company. The only way for Heritable to have avoided the extinguishment of its claim would have been for it to lodge it in Landsbanki's winding up, even if it would not have been cost-effective to do that, or the prospects of recovery were nil. It would also give universal priority to the process in which the decision happened to be made first. This would encourage forum shopping, and it is hard to believe that that was intended by the framers of the directive. For these reasons, the Court holds that Heritable's administrators are entitled to use the Heritable claim against Landsbanki's claim by way of set-off in the administration. The Court will now adjourn.